The torts question from February of 2009 is a difficult, short fact pattern. Have a look at the call of the question. How should the court rule on each ground of the motion to dismiss? Discuss. Well, that doesn't tell us a great deal, and it might even be a civil procedure fact pattern for all we know. But we do know there's going to be more than one ground for the motion to dismiss, and failing some other bright idea, we're going to organize our answer around each ground of the motion, and to the extent that any one of these grounds break up into elements, then we'll consider the elements. Go to the top of the question, and in paragraph 1, we meet Consumer Pro. It turns out they're our defendant. They're a consumer protection group. They publish a manual about plaintiffs' lawyers in tort cases. The manual also includes comments that rate the attorneys. The manual is distributed to members, and it helps them pick lawyers. So, in paragraph 1, we learn background information, but so far, there's nothing going on that gives rise to litigation. But take a look at paragraph 2. Paul, our plaintiff, is listed in this manual. He is a car accident lawyer, and in related comments, here's the key quote. Paul is reputed to be an ambulance chaser and appears to handle only easy cases. Basically, these are two statements, not one, and we're going to talk about them separately. But look at paragraph 3. Here we learn about the lawsuit. It is a defamation action. It alleges injury to reputation, and it requests general damages. Well, take a look at the statement, both of the statements. Paul is reputed to be an ambulance chaser. Is that a defamatory statement? He appears to handle only easy cases. Is that a defamatory statement? Taken as a whole, is the whole thing a defamatory statement? Now, maybe I'm just revealing, once again, my defense lawyer bias, but I just don't think it is. Now, have a look at the second sentence in paragraph 3. Consumer Pro moved to dismiss for failure to state a claim on which relief could be granted. And here we get the four grounds. 1. The statement was non-actionable opinion. That might be a pretty good ground to dismiss. 2. Paul failed to allege malice or negligence under the U.S. Constitution. Well, we'll be able to split that up into a couple of different pieces, perhaps. 3. Paul failed to allege special damages. That's an interesting and a highly technical question. It's interesting for me to talk about, but it was hardly interesting for most of the candidates that had to write an answer to this question under timed conditions. We're going to have a careful look at this topic. And then, ground number 4, in any event, the statement was privileged under the common law. Essentially, a crossover into the law of evidence. It's very interesting. How should the court rule on each ground of the motion to dismiss? Discuss. A fairly straightforward question, given that we are handed all four grounds for the motion to dismiss. Now, take a look at the outline of issues that I've written. Here you're going to see, once again, an example where I have taken an essay question and reduced it to 4 short answer questions, which fundamentally is what's going on here. So with regard to the first ground, that Consumer Pro's statement is non-actionable opinion, I talk about each statement separately. Now I imagine one readily could answer this question in one big fat paragraph with no internal headings at all. But as we think about systematically approaching these questions with an eye towards careful organization, it's clear that there are 2 different statements in Consumer Pro's statement, and I talk about each of them separately. And you'll see that I conclude that the defense motion should be granted because, in fact, both of these statements are not actionable, their opinion. And by the way, I think there's plenty of room for a candidate to write a persuasive answer that reaches a conclusion sympathetic to the plaintiff. Although I would say that my answer is the majority answer. I think that most of us who carefully reflected on this question would agree that the statement that's referred to just is not defamatory. Now turn to question 2, or ground 2. Here, this turns out to be a somewhat more narrow question than it might have appeared when we first looked at it. I talk about it very briefly, in one big paragraph essentially, for the first part, and then the conclusion. Next, part 3, that Paul failed to allege special damages. Well, this is another fairly technical area of law, and you'll see that I go into a distinction between general damages, which are presumed in Part A, and special damages, and how special damages must be pled to be recovered. Now, this is about as highly technical an area as you are likely to see tested on an essay question from torts. In the end, I grant the defense motion. But as you'll see when we get to a review of my answer, this is quite a close call, and there's a great deal of room for reasonable arguments to be made on both sides. The question for Part 4 is another awkward, difficult question, this issue of privilege. And you'll see in my outline of issues, the only thing I can think of to break it up into slightly smaller pieces is to consider the distinction between an absolute privilege and a qualified privilege. Here again, I grant the defense motion. Now let's take a brief look at the answer that I've written to this essay question. This is a very straightforward answer by me, and I think you're going to see that it's a good example of how I use the facts to distinguish one area of law from another. This is quite an in-depth question about defamation, especially looking at it from the point of view of the defense. And that makes it a fairly unusual question, because by and large, in torts, we're looking at it from the point of view of the plaintiff, although obviously we give the defendant his or her day in court too. But here we are looking at a technical area of torts law from the point of view of the defense. It's an interesting question, and as you look at my answer, you'll see at the very beginning I start off with a quick definition of defamation, and then I go on to discuss the procedural context out of which this motion to dismiss arose. I focus on each of the two statements. Paul is reputed to be an ambulance chaser, and he appears to handle only easy cases. Now, as you look at the analysis that I provide for each one of these statements, I think you're going to agree that it isn't really possible to go into a lot more depth on either one of them. Now, perhaps one could go into an equal amount of depth and reach the opposite conclusion. But it does seem evident to me that this defense motion should be granted because the statement isn't actionable. It isn't defamation, it is non-actionable opinion. Next, with regard to the allegation that Paul failed to allege negligence or malice, here we are dealing with a crossover between the torts outline and constitutional law. Now, you already know that I don't think very much of this justification for dismissing the plaintiff's complaint. And suppose the defendant won this motion on this grounds. The plaintiff easily could just go and amend the complaint and refile it. But let's take a look at the First Amendment issue presented, the idea of a public figure or a public concern. Now, this happens to be a little area of law that the California essay examiners have tested quite a few times over the last 20 or 25 years. And here we see that we've got a plaintiff who, in a defamation action, who is upset over statements that are made in a context in which the plaintiff appears to be, at least a limited purposes, public figure. And not only that, but the matter that the comments arise out of is one that is one of public concern. And so, under those circumstances, the plaintiff, in Paul's position, needs to show malice. And here I conclude that although it is true that the plaintiff may not have filed a technically perfect pleading, again, if the defense wins this motion, the plaintiff will be able to amend and refile. In other words, the allegations can be repaired. Now turn to Part 3, this issue of special damages. I find this to be an unusual issue for an essay question, and that's a good reason for us to have a look at it. I think you'll probably see questions similar to this testing exactly this issue on the multi-state, but it's not common for it to show up on the essays. Notice that in my answer to question 3, or ground 3, I lead with the facts. We've got a plaintiff who alleged injury, but only requested general damages. Now, whether or not that's good enough depends on whether or not any of these statements can be considered a per se defamation. Now, you already know I don't think the statements are defamatory at all. And even if they are, I think it is extremely difficult to argue that they are a per se defamation. And what that means is there's no reason to presume damages. And so special damages would have to be specifically alleged. So in the end, I conclude that Paul's failure to allege special damages justifies granting the defense motion to dismiss, assuming that the defamation Paul alleges is judged to be less than a per se defamation. So once again, we've got a very narrow area of law being tested at great depth. Finally, we turn to my answer to ground number 4, that Consumer Pro's statement was privileged at common law. And here, I go into a tiny bit of law about how common law does offer protection for freedom of speech that is independent of the Constitution. And the two types of common law privilege are absolute privilege and qualified privilege. And it seems to me here that the defense has a strong argument that the statement is protected by the qualified privilege. And then, at the very end, on the last page, I go into the distinction between the absolute and the qualified privilege, one that, to my knowledge, never has been tested before exactly in this way on California essays. I conclude that privilege is yet another good reason to grant the defense motion. I don't think Paul has stated a claim. And that wraps up a consideration of a question that I think you will agree is surprisingly technical and deep and difficult.